Welcome, everybody. My name's Christian Marlow. If you don't already know me, I'm the Policy Officer at SCA Queensland. I'll begin today by acknowledging the traditional custodians of the Yagara country on which we are hosting this webinar from today and pay my respects to their elders past, present and emerging. I extend that respect to Aboriginal and Torres Strait Islander people here today. All right, everybody, welcome to this webinar. It's a very exciting time to be in body corporate in Queensland. So I want to thank my colleagues, our two advocacy directors on our board, Ms. Jessica Cannon and Mr. Duncan Lee, for kindly volunteering their time on incredibly short notice to make sure that we can keep you up to date with the proposed reforms. And I do want to, at the outset, say that, ladies and gentlemen, these are at this stage only proposed reforms. What does that mean? They've been introduced into the Queensland Parliament by the Attorney General. There will be a committee process where members of the public and organisations such as our own will be able to make submissions on discrete amendments. But Queensland has a unicameral parliament, which means, long story short, what the government says goes. There's no negotiating. When you have a majority, you get things done. With that, I'll get us underway. Okay, so I'd like to also thank our corporate sponsors for their ongoing support of SCA Queensland, in particular our platinum partners, Macquarie Bank, BCB, Altogether, Strata Max, and Grace Lawyers. Before we get underway, some housekeeping. For CPD purposes, if you are screen sharing, please let us know in the chat or alternatively email membership.queensland@strata.community within the next 7 days to advise. If you do not advise within the next 7 days, we will be unable to award CPD points. If you have registered for the webinar, your CPD points will automatically be allocated. So just to cover off again on my fine colleagues who are with me today, we've got Jessica Cannon. She's a partner at Grace Lawyers. She's an advocacy director with Strata Community Association Queensland and a very highly respected body corporate lawyer. Mr. Duncan Lee is a very senior body corporate manager and the owner of Pinnacle Strata. He is a senior vice president at SCA Queensland and also one of our advocacy directors. Alrighty, ladies and gentlemen, without further ado, let's get into it. And I want to stress again that these are only proposed reforms at this stage. They are likely to pass very much as they are drafted at the moment, but the law did not change on Friday or Thursday. So I want to make that absolutely clear to everyone. All right, so let's get stuck right in. The changes. So the policy objectives of the bill are to deliver a key action of the 2022 Queensland Housing Summit by reforming the BCCM Act to allow for the termination of uneconomic community title schemes to facilitate renewal and redevelopment. So you're all aware that Queensland is in the midst of a housing crisis at the moment. So there's a very big emphasis from government at all levels on helping drive new housing supply. So that's a core part of this bill. Secondly, the government is keen to deliver on a 2020 election commitment to implement amendments to the BCCM Act to allow an adjudicator to approve alternative insurance arrangements and make supporting amendments to complement this change. And this will include certain standard format schemes being able to apply for alternative insurance. Modernise and improve the operation of the BCCM Act in relation to bylaws and other governance issues, including administrative and procedural matters. Strengthen buyer protections under the Land Sales Act by limiting when sunset clauses can be used to terminate off-the-plan contracts, and also make minor amendments to confirm the policy intent of existing provisions of the BCCM Act, BUGTA, Land Sales Act and South Bank Act about the release of deposits paid by buyers under off-the-plan contracts for the sale of land or lots in community title schemes, including BCCM Act, BUGTA Act, and South Bank Act. So, quick summary of key amendments for strata managers. Four big areas: pets, smoking, and towing. So pets, smoking, and parking, which are three of the biggest issues facing strata managers, and then obviously also scheme termination. So we're going to start with the issue or the changes surrounding pets, which is obviously a hot topic as more and more people declare their pets fur babies. So without further ado, I'll pass over to Duncan.
Thanks very much, Christian. Yeah, look, this one's pretty straightforward when it comes to the proposed changes because what is proposed in the bill is relatively consistent with what's been in practice for a number of years now. There are a few minor tweaks that may raise some eyebrows upon initial read, but they're probably for the greater good anyway. One particular one that jumped out at me was the proposed section 169B2B, which is basically saying that a bylaw must not restrict the number, type, or size of any animal that an occupier of a lot may keep or bring onto the common property for the scheme, which sounds as though the legislation may allow somebody to keep a pet bull in the back of a suburban backyard. But we have to remember that the local government ordinances supersede any bylaws that might be in place for a body corporate. So the proposed changes are quite reasonable and reflect what's already in practice now. They also do codify that a body corporate can impose quite a lot of conditions on those approvals, but those conditions can't be unreasonable. So it's relatively straightforward, and as Christian's pointed out, it really does acknowledge that pets are becoming more and more part of the extended family rather than just how they used to be treated in the olden days. So some of the things that are excluded in terms of, some of the reasons why pets can be excluded is, say, for argument's sake, if a body corporate was in a conservation reserve, or if there was a risk to somebody's health and well-being if they were specifically allergic to a type of pet. But it's really just formalising the understanding of what we already know with the application of bylaws through adjudications.
I think it's really important to note here, Duncan, as well, that these amendments by no means are eliminating a body corporate's voice or say in terms of still having rules and regulations around animals being on scheme land and animals being kept on the lot. And I think my fear with this amendment is a lot of body corporates, a lot of committees may say, well, look, essentially we're just this rubber stamp. And look, I take point that there has been a huge influx of adjudicators' decisions recently that really go to pets and questioning the reasonability to challenge pets. But there is still a say. So please ensure that when you're communicating these amendments to your committees, to your owners, to your occupiers, there is still the ability to have a permissive bylaw in there. You can still make your permissible bylaw subject to prior body corporate approval. And it's still, as Duncan has said, it can still be conditional on reasonable conditions as well. So it's still very proper, very valid for a body corporate to regulate pets and animals on scheme lands. All these amendments are really doing is looking at taking out a large chunk of pet disputes that have happened in recent times and putting them into the Act to essentially say, you can't limit number, can't limit size, and can't limit the type. But obviously everything, as Duncan has said, is still conditional on your local council rules and regulations, most of which go to number, type, and size as well. So there's still that level of comfort that can sit there for body corporates.
Very good.
Yeah, absolutely. Thank you. And we'll move on to smoking. So pet disputes probably aren't quite over, which is potentially exciting for the body corporate lawyers out there, but hopefully they're minimized as much as possible.
Oh, it's inevitable that there's still going to be disputes about what reasonable conditions are, Christian. Come on. It's still a level of grey there.
All right, smoking. Might hear from Duncan on this one.
Yeah, thanks again, Christian. Yeah, smoking's another one that's been a hot topic for quite a few years now. And again, this is really codifying what we've already come to understand in terms of where a body corporate can make bylaws in regards to smoking, and making it very clear that a body corporate can make smoking prohibited from outdoor areas, including common property scheme land and body corporate assets that owners and occupiers may use. It does exclude common property or assets that are covered under exclusive use bylaws, so the body corporate can't extend that prohibition to areas that are included within the boundaries of the lot or exclusive use attached to a lot. But it does make it very clear that the body corporate can have more restrictive bylaws in regards to smoking. It's also good that it covers basically everything that's covered under the smoking legislation. So any smoke or inhaling of any smoke products. And again, in my mind, very comprehensive in terms of how it's covered. Quite prescriptive. And the upshot of this, and even the last one, is that it's a good catalyst for committees to consider whether their current bylaws are appropriate to address these new regulations, and if they do want to enforce smoking and pet bylaws, then they should consider having a revision of those bylaws. Jess, did you have any comments on these ones?
Yeah, look, I think this is essentially a mirror image of the famous Artigue decision, isn't it? It's where the adjudicator ultimately made a finding that smoking on a balcony and smoke drift cause from a person smoking on the balcony was a hazard. So what these amendments really look at doing is adopting that same thought process and allowing a body corporate, and Duncan makes a great point there, and it's one that I want to make really clear when it comes to the pets, smoking or towing that we're about to get in. These are all bylaw related matters. So when you're talking to your schemes and your committees, it's not just going to be a case of, well, the Act has been amended to facilitate this. You still need to have a permissible bylaw in place. So it's really important that you look at your portfolios and make sure you're reviewing what your scheme's bylaws say, because that's what they enforce. They enforce their bylaws as they currently stand. That may trigger a bit of a flurry of bylaw amendments and the like as well, but it's important to make sure there's consistency between your scheme's bylaws and also these amendments if, like Christian said, they do ultimately be passed. But look, in my view, that the big ticket items that are going to be here is balconies, whether they're on the lot or not. That's going to be the really big ticket item. And what it's practically probably going to result in is persons who wish to smoke either need to smoke within the internals of their lots or within a designated area of the common property or off scheme land. That again is assuming that your body corporate ultimately resolves or already has in place some form of bylaw which will mimic these new amendments to the legislation.
Yeah, and just another addition to that, Jess, you asked a good question before we started. What could be considered a body corporate asset on which a smoking prohibition could be enforced? Say a marina, jetty, something of that nature would be an asset because those areas are over usually a seabed lease, so they're not included in the scheme land, but are considered body corporate assets.
Yeah, and look, it makes sense, doesn't it, Duncan, for when they're drafting this bill, they're looking at, common property, but also what are some other areas that aren't technically speaking common property, but ultimately may still cause that nuisance or hazard. And it did. It spiked my interest. So I was trying to think of what would be a body corporate asset that this type of amendment would apply to. And I agree, marina berth or the like may be one of those that your schemes and your portfolios need to look at as well.
Yeah, the body corporate Ferris wheel or something like that as well.
Why not? I think it's just before we wrap up this smoking part too, I particularly liked the amendments recognising the fact that a bylaw which prohibits or restricts smoking within these areas, whether common property, body corporate assets, or the like, it's not going to be considered oppressive and unreasonable. And I think the practicalities of that is recognising that most smoking bylaws or most challenges to bylaws come down to whether it is ultimately oppressive or unreasonable. And this bill looks at taking it a step further and essentially saying, well, if you mirror these amendments in your bylaws and you put into place what these amendments say and how the restrictions apply, then it's not going to be considered oppressive or unreasonable as well. So it's good to have that type of declaration built in there too.
Just before we go on, I want to probably let everyone know something from an SCA perspective. So you probably saw we did quite a bit of media on Friday regarding this topic, and it's always important to enhance community awareness of body corporate. But a lot of people thought that this meant a blanket ban on smoking on balconies, for example. And I think it's really important from a community education perspective that Strata managers play their role and communicate clearly with committees, as Jess said, the need to update your bylaws.
That probably ties in, Christian, quite nicely to Ronald's comment that he's left in the chat box there, is please define oppressive and unreasonable. That's such a wide principle to apply. It really depends on the individual facts and circumstances. But what Christian just said there is, if you have a body corporate that tries to amend its smoking bylaw to place a blanket prohibition on smoking on scheme land full stop, that could potentially be considered oppressive and unreasonable. Why? Because it goes beyond what these amendments are saying. These amendments are focusing on all or part of common property and body corporate assets, or all and part of outdoor areas. And that's very much leading back to, where do we see the effects of smoke? The smoke drift, and that smoke drift causing a nuisance or a hazard as well. So that could be an example, Ronald, of where we see these types of oppressive or unreasonable arguments coming into play with smoking, for instance.
And Jessica, I'll just add to that as well, because it is very hard to define, because bodies corporate covers such a wide gambit of properties that something that might be applicable to, or might be considered oppressive and unreasonable to a commercial body corporate that includes, say, a tavern with a designated outdoor smoking area, would be very different to a residential property.
Agreed. Yep, agreed. You've got to consider that the structure of the scheme, the use of the scheme as well. And look, I know some residential schemes have designated smoking areas with the view of trying to curb where smoke can occur and smoke drift can come from. So, it really does depend on the individual factual scenario of each.
Yeah. And Michael Hurley's asking a question about what smoke is included, whether it's smoke from a barbecue. It's very specific that it's under the Tobacco Use Act. I can't find the exact reference.
Tobacco and Other Smoking Products Act of 1998.
That's the one. Thank you.
So that includes vapes, for everyone who is about to ask. Yes, vapes, pipes, hookahs, cigarettes, cigars, anything pretty much, but not barbecues. Anything used specifically for smoking. All right. With that in mind, we might move on to towing. And thank you for those questions, team. They've been very, very good. So, Jess.
Sure. So the other notable amendments as well, Christian, that came from this bill goes to towing. And the two key sort of notable amendments that I've pulled out is, first and foremost, that the bill actually includes an acknowledgement in there that the Body Corporate and Community Management Act does not prevent a body corporate from towing a motor vehicle under or from common property under any other type of act or pursuant to or in accordance with the law. So what jumps out to me in this amendment is the argument of trespass ultimately as well. Now that has, considerable variables and applications and the like, but I think obviously it is a big ticket item that perhaps the Commissioner's Office or other stakeholders have raised, saying, well, can we still tow under some other law that's available to us rather than pursuant to the provisions of the Body Corporate and Community Management Act? And the drafters obviously thought it was significant enough to think that they need to build in an amendment there as well. So not that I think that changes the law in any way, it's just really an acknowledgement that sits in there for the industry to take note of. The other important amendment is that if the body corporate does have a valid and permissible bylaw in place which facilitates towing or permits towing and a process attached to it, and a motor vehicle is owned and operated by an owner or occupier within the scheme, it's parked on the common property and it's acting in contravention of that permissible bylaw I was referring to before, then the body corporate's not required to follow the bylaw contravention process in order to tow the vehicle. I think that's still a really important amendment that's come through, because what it's looking at doing, at least on my view, is expediting the process. I don't know about you all, but the biggest grievance I always hear from committees is the process is so long that by the time I actually get an order to tow, the vehicle's been moved or the person's moved out or the owner has sold their lot, whatever the case may be. So as much as these amendments are probably not what your committees would ideally want to see, they do go a long way in terms of trying to expedite and shorten the process in order to get the vehicle towed. Where I see the complications with these amendments is still identifying the vehicles. That's always been a bugbear of mine and always been a practicality that I've heard committees complain of, especially in larger arrangements or schemes, especially in later schemes. How do we know what's an owner vehicle or an occupier owned vehicle unless you have some type of identification system or tagging and sticker system? That can be a really difficult process to go down as well. But I do think this is a positive step for our body corporates to know that there is some form of quicker or more efficient process to go down when you need to tow a vehicle.
Yeah, agreed. And just for all the body corporate managers out there listening, this is one of those areas where it'd be worth just reinforcing to your committees that if they do have a bylaw of this nature and they do wish to exercise their right to tow a vehicle, that they do so with an abundance of caution. Without a very clear definition of who even qualifies as a visitor or an occupier of a lot, you don't want to create a new problem, a bigger problem by solving a small problem.
Look, I agree with that as well, Duncan. There's risks still in towing, and really what this amendment looks at doing is cutting out those preliminary stages that need to happen. I would suspect, and Christian, I don't know whether you can comment on this, but I would suspect that still towing disputes may still need to go to conciliation first through the Commissioner's office. So there's still going to be steps involved in getting there. And a permissible bylaw is really important because a lot of these amendments are contingent upon that valid and enforceable bylaw sitting there in order for this process to be taken.
And just in addition to that, I did notice that in the explanatory notes for this particular bill, it did make quite a lot of reference to appropriate signage for the body corporate's right to tow vehicles, yet there's no clear explanation of that in the bill itself. Do you have any thoughts on that, or is this something that will just come out in the wash in practice?
Look, I don't think they would ever put into the bill or into legislation the need for appropriate signage. I think there's so many cases out there which supports that. The concept behind not every vehicle owner is going to be aware of what the bylaws say, and that's why your signage is so important. And I still think that's the same process as when you come down with these amendments. If they're passed, you need to make sure that your signage is very clear, that they canvass what the rules of use are, who can use it, for how long. and also place the vehicle owner on notice that there is the ability to tow if the vehicle owner contravenes the parking rules and regulations as well. So most certainly, Duncan, I think that's still the same as what most body corporates, at least what I hear of, are following now. That signage still needs to exist. We're just trying to expedite the process to actually get a vehicle towed if we need to.
Yep. Anthony Robbie's asked a question: is there a need to still attempt to self-resolve with a vehicle that's contravening the bylaw? Under my understanding, it's under the proposed section 163A2. It specifically excludes the requirement to go through the normal bylaw breach process. So if that's excluded, Jess, would that be exclude the need to go through any type of self-resolution? If they're in breach, and have a bylaw in place, they can tow without, provided they followed the appropriate action under the bylaw, without having to go through any other self-resolution process.
That's a great question, Anthony. Thank you. And look, I tend to agree, Duncan. I haven't read anything. And again, you know, we obviously put this together pretty quickly, but I haven't read anything in terms of self-resolution attempts. And that's why my query on, you know, conciliation being a mandatory step, question mark on that as well. But my take on it is we're not having to go down the path of bylaw enforcement. It would seem strange that a body corporate would still need to go down the path of self-resolution attempts.
Very good.
I'll clarify a couple of things. So Roland Franz has asked, if a vehicle is not registered, you can tow an unregistered vehicle at any time presently under Queensland law. That's a general principle. Secondly, Colette Dunn, re-smoking, what about under an SFP? Will their yard be, with their yard being on the lot, the yard forms part of the lot and therefore they commit. So it includes outdoor areas of lots. So courtyards, you will be able to ban smoking in courtyards if you have an appropriately drafted bylaw. And Claire Stewart, relating back to pets, it mentioned risk to humans. Does this include breeds? The example given in the legislation was around an anaphylactic allergy.
Yeah, normally medical reasons come into play there, and it's especially topical when you have persons who are frequently on common property, i.e. service contractors or contractors that have any type of medical conditions or allergies to pets. That's my read on where that risk to human life comes into play. The breeds component would come under council regulations in my mind as well. There is a list that local councils publish about restricted breeds of let's just say dogs, or there is also the provision for dangerous or menacing dog declarations. So they're all reasonable. Well, my view would be they're still reasonable conditions that would come into play, but more so enforceable at council level rather than at body corporate level.
Right. We might move forward to the real nitty-gritty part of the afternoon, which is scheme termination. And I'll hand this over to Jess, but just start by saying, to be clear, this is not a blanket 75% threshold for scheme termination. That was a question we were asked by the media several times on Friday, and unequivocally, it is not.
Yeah.
It is not. But Jess, I'll now hand over to you. I just wanted to make that super duper clear for everyone.
Thanks, I appreciate you making it really clear. Yeah, look, I can understand where, because of the media hype that these amendments have created, where that probably that misunderstanding of these amendments has come from. As we're about to go through in detail, there are a lot of steps that are going to be needed in order to get to that 75% vote to terminate a scheme. And a lot of it's quite descriptive in terms of how to do it. And what I will earmark at this point is Duncan and I have spoken today about the advocacy arm of SCA creating some type of fact sheet, flow chart or the like to really try and help you all, but also your committees if these questions do come up about what's the process that's ultimately involved in it. Because if anybody has read this bill, it's complicated when it comes to termination, and there are some steps and there are still some grey areas, which I'll go over a little bit in a minute as well. So please don't think that this is going to be our only webinar going to this. We're going to produce some more material that will really help the membership as well go through this process. So as Christian said, not a blanket rule on 75% to terminate schemes. However, there is still the ability to terminate a scheme on a resolution without dissent. I also got asked that question recently. So this isn't just the only way that terminations of schemes can now proceed if this bill is ultimately passed. So what the 75% rule and the new scheme termination really looks at doing is turning its mind to those schemes that, for economic reasons, which I'll loop back to a bit of a definition on that front in a minute, for schemes that for economic reasons want to terminate, how can they proceed with termination when there's such a high resolution type of a res without dissent to go through? And what this scheme looks at doing is saying, okay, what's the process? What's the system in place? How can we try and balance all owners' property rights and perspectives against the vast majority who say it's just economically not viable to maintain this scheme in place? So what it looks at doing is the preparation of a pre-termination plan. So the pre-termination plan really looks at containing some prescribed information to assist a body corporate to decide whether there are economic reasons for termination within the proposed bill. And when we talk about economic reasons, the legislation committee has spoken a lot about this before. It's intriguing because there's still a lot of grey. And for those that are interested, you can jump into the bill and have a look at the proposed section 81 capital A, and it talks to you about what your economic reasons are going to be. And what it looks at doing is saying, well, either now or in 5 years' time, the body corporate is not or will not be viable for the body corporate to carry out repairs and maintenance to the property to maintain it in a good or structurally sound condition. So I think most of us can agree that how you apply economic reasons is quite subjective, and different people can apply it in different ways. But what the intention, at least from my view, is looking at those dilapidated schemes, those old schemes that need a lot of work, whether it's in structural work or whether it's in waterproofing works or the like. They're ultimately in a dilapidated state and they need a lot of work, a lot of repair, a lot of maintenance costs in order to keep the body corporate operating to the standard that we ultimately desire our body corporates to be in as well. So assuming that your body corporate or a body corporate within your scheme thinks that there are some economic reasons for termination, there's quite a few steps. And what Duncan and I have calculated today is about 3 resolutions that are going to be needed at general meeting level in order to see this process through. So the first resolution is a majority resolution that's needed. And what it looks at doing is saying, okay, do at least the majority of owners agree that economic reasons exist to trigger this termination plan, or at least invest further in a termination plan as well? Now, my reading is assuming that economic reasons resolution passes, then we need to look at a termination plan. And that's your second point. But Duncan made the very good point today, didn't you, Duncan, that the bill isn't actually clear on whether the economic reasons resolution has to go first, or whether an economic reasons and a termination plan resolution can go into the one general meeting. So we'll have to canvass that in a little bit more detail and digging as well. But your first step is thinking, are there economic reasons? Your second step is, and assuming that there are economic reasons, then the body corporate may also pass a termination plan resolution, which ultimately requires the body corporate to make a termination plan, which contains important information to all lot owners to consider about the process of undertaking a sale of the community title scheme, importantly to a single entity for terminating a scheme. So they're your first two steps: economic reasons that exist, and then secondary to that, ultimately your termination plan as well. Is there anything that you want?
Yeah, I was just about to add a couple of things in there as well. Is that I think it's important to note that while economic plan, where are we back to? Looking at the terminology, basically economic reasons specifically does not include that the value of the property is increased by having a DA approved for a more comprehensive development. So what I'm saying by that is that the economic reasons can't simply be that the property is worth more if we develop it. It's specifically saying that it's not economically viable to continue to repair and maintain the body corporate assets and common property. I think that's an important distinction there.
I agree. And I think the other hard part with this as well, Duncan, is when it comes to more of what I take to be your residential type schemes, you're looking both now and in 5 years' time as well. So there is going to be a component in these amendments, which is really looking at, in 5 years' time, forecasting what's our scheme going to need then, and what's the cost going to be. I think we can all agree the cost of any type of building or construction work has jumped significantly post-COVID times. It's going to be difficult, or potentially difficult, to forecast what that's going to be in 5 years' time as well.
Yeah, and I think there's probably one other thing for everyone to take into consideration while we're talking about this, because this is complicated. It is convoluted, probably by necessity. There's probably a reason to have this much complication in having a new format for terminating a scheme. But in other jurisdictions where similar legislation is already in force, in most of those jurisdictions, this type of legislation hasn't really been enacted. It's simply been a mechanism to encourage a negotiated termination to the scheme. So it's a catalyst to having progressive negotiations rather than allowing a single individual to be a holdout for everyone.
And I'll make a couple of points. First is, everybody understand, as we go through scheme termination, you're probably going to have more and more questions, but if you could just leave them till the end, because this process is very, very structured. So if we get to the end and we've explained it and you still have queries, please, we'll answer them then. Otherwise, I expect that as we go through this, your questions will be answered. Secondly, just to build on what Duncan said, there are so many steps to this that it will likely be very unlikely that it'll be dragged through all the way to the end. But it's about helping owners let go of a bit of emotion and really look at where their scheme is at and what is the sensible option for them. So I'll pass back to you, Jess, but I just wanted to drop those couple of...
Yeah, look, I appreciate it. Thank you both. And I think the only other important part to remember here is there's a distinction in the proposed bill about schemes that are used for commercial purposes when it comes to defining economic reasons, and that's that it's not economically viable for the scheme to continue. Again, I think everybody that's probably dialed into this webinar would have a different way of applying that. And it's like any law, right? Whatever's in the legislation, it says what it says. But until we start seeing courts ultimately apply that, that's when we see the practicalities of how these potential disputes could ultimately play out as well. In terms of the termination plan, what I particularly liked in this bill is it actually steps through some criteria that needs to be included in that termination plan. So what is it exactly that we want a body corporate to produce in this plan? And it steps it out in 81 capital B as well. And it's the practicalities, it's the nitty-gritties, right? We're putting up a motion to owners to ask owners to approve to sell their lot to one entity and ultimately dissolve the scheme. Well, most owners are going to turn around and go, okay, well, like, what does that look like for me? What's my sale price going to be? When do I need to be out by? What's going to happen with the body corporate assets or the money that's sitting in the body corporate bank? It's those practicalities of the process as well that are spelled out in that termination plan. So if you're interested, and again, we will put together some more information on this, but if you're interested in the meantime, 81 capital B steps out what that termination plan is going to need to include.
We might move forward to the next slide. So there's multiple slides on this because, as we've alluded to, it is quite a convoluted step-by-step process. So Jess, carry us forward.
Sure. So once we've got, let's say we've got the majority resolution for the economic reasons, we've then got a majority resolution for your termination plan to go ahead. Once that's all prepared, the body corporate needs to provide lot owners with a copy of the termination plan for consideration, following some prescribed timeframes. And Christian, I think you alluded to this before. It's a very structured process with very rigid timeframes involved in it. And the reason why, which we'll come to in a minute, is where aggrieved persons or parties can ultimately challenge any resolutions that are made, how they can challenge them, and in what time frame. So it is very, very important if you were to have a scheme that goes through this process for the timeframes to be at the forefront of their minds and of your mind as well. So following the prescribed period, the body corporate may hold a general meeting to consider a motion to terminate for termination resolution, which in summary is a resolution to implement the terms of the termination plan in order to terminate the scheme. Now, it's at that time where you've got your 75% or more of all lot owners vote on the motion. So this is where different steps carry different resolution types. Each of them also carry slightly similar notification periods to owners, but also other challenges in terms of notification timeframes and what documents to be provided. In my view, this, and like Duncan said before, there's a lot of terminology used throughout this bill, which again, we'll work on some fact sheets and the like. But this termination resolution, as the proposed bill is saying, this is almost your final step. This is where you're saying to owners, okay, we've got the economic reasons, the majority of owners support that. We've now got a termination plan going into that nitty-gritty practicalities of how we're going to work through this. And we've got our majority resolution to carry that. Now we actually need to increase the threshold to 75% or more in order to get owners to approve the ultimate termination / dissolution of this scheme to occur. So the body corporate, if that motion for termination is passed, the body corporate must notify certain parties with an interest in the scheme of the notification and must appoint a person as a facilitator to assist the body corporate in the implementation of the plan. And this is really important here as well, because at various times, if these resolutions are passed, the body corporate, more often than not, I actually think on all 3 steps, but correct me if I'm wrong, Duncan or Christian, has a 14-day notification period. And what I mean by that is, let's say that the body corporate has the termination plan resolved. There is a 14-day period where the body corporate needs to notify a class of interested persons of that decision that has been made. Now, I find that personally quite interesting, because most owners will become aware of it through the minutes, which will be prepared in a 21-day period. But the interested persons is actually expanded beyond that. And different resolutions in this process trigger a different class of interested persons that need to be notified of these resolutions that are being made as well. But again, that's also a time frame that you need to turn your mind to. The purpose of the facilitator is to actually help with the practicalities of the implementation of that plan. It's like, okay, we've done this. We're now about to engage in this process in a bit more of a meaningful way. Let's see the actual implementation. Now, following implementation of the termination plan, including transfer of the ownership and scheme land to the purchaser, being one entity, the community title scheme can be terminated through lodgement and recording of various different documents under the Land Title Act, and that's ultimately the end of the body corporate. It's dissolved. So again, I know it seems like a very long process, and it probably will, especially the first few that will go through this, but it's designed to balance the rights of owners and ensure that body corporates going down this path meet that economic reasons or economically viable test to ensure that really the purpose of this new scheme is being used correctly within the industry as well.
And I'll just build on that. So when you're getting your pre-termination report together, this is a very thorough document set out in 81C. So it has to include, and this is without limiting what may be included, it must include the following: market valuation of each lot in the scheme, market valuation of the scheme land, a document prepared by the body corporate that states the estimated value of each body corporate asset, the nature and estimated value of each liability of the body corporate. If the body corporate decides the termination report must include information about whether economic reasons for termination exist, a report by an appropriately qualified person on whether the lots can be used for an economically viable purpose. That's if it's a commercial scheme, I should say. If the body corporate decides the pre-termination report must include information about whether the economic reasons for termination mentioned in section 81, capital A, small bracket, B exist, a report by a structural engineer on the condition of any property or assets the body corporate must maintain, a report by a suitably qualified person taking into account the report of the structural engineer or the works reasonably required to maintain, repair, or if necessary, replace any property or assets, and a report by a quantity surveyor estimating the cost of the works identified in the report provided. And it also contains some provisions around preventing people from appointing people who have a conflict of interest. So that's a really thorough document, and you're going to be able to, if you're faced with a couple of owners who are quite married to staying with the scheme, you're going to be able to provide them with some real cold hard figures, because they're going to know how much their lot is worth, but they're also going to know pretty much how much they're going to be on the hook for to get the scheme up to an appropriate standard. So that for me kind of really is about, that demonstrates how thorough they've been in thinking about this, so that we really know what you're going to have to hand to people when this process gets underway. Now, there are further provisions around disputing all of that you know you can consider, and we won't, just because of time constraints. But most people, I would hazard a guess, most reasonable people, if that pre-termination report looks like that, you know, it might cost $250,000 to make good their $500,000 unit, I think most reasonable people will make the rational decision. And that goes to what Duncan kind of talked about at the very outset of this, about guiding people to a negotiated termination. I think.
Yeah, I think the buck would stop in most instances at section 81D, where that information is distributed to owners. And I would be surprised if there's more than one scheme, or even one scheme, terminated a year under these provisions in the future. It's really a catalyst to a negotiated resolution.
Yeah, look, I agree as well. And I think following on from that, in those rare circumstances, there are mechanisms built into this process for aggrieved persons to challenge certain steps. So the way that the proposed bill is structured now is there is a challenge right after the economic reasons resolution to take it to a specialist adjudication. But then there's also the ability to challenge the termination plan in a court of competent jurisdiction as well. So again, we won't go into those nitty-gritties because only certain classes of persons can be classified as aggrieved persons to bring those types of actions. That might be a part 2 of this webinar that we'll need to go into, but there's still recourse. And that's the importance when balancing this process, is to making sure that there's natural justice afforded and persons that are aggrieved can take the appropriate action if they deem necessary. All right.
Like I said, that was going to be very thorough. And thanks, Jess, you've done a fantastic job. I think everyone's going to be significantly clearer, though I suspect it'll take a few famous cases for this to really sink into everyone's mind about how this will work in practice. But in theory, at least, everyone should hopefully have that bedded down to a reasonable level, I hope.
Well, look, and like we said, Duncan and I did have a good chat today about this, and it's taken us a bit to wrap our heads around the process and the terminology and the timeframes and everything else. So for those that know me know that I love a good flow chart. I think Duncan's pretty similar.
Agreed.
So we will work on something that we can distribute out to try and help illustrate the process. And I think a big part of that is the terminology and where things fit in as well. So leave that with us and we'll take it on notice and come back to you all when we can on that front.
Just had a question pop up. Going back to towing, can we clarify the comment by Christian being able to tow an unregistered vehicle at any time? I don't believe that's currently the case. You can tow an unregistered vehicle at any time. You may see on occasion cars with a sticker that says police aware on them. That means the car has a registered owner. It's been left somewhere, but the police have been unable to contact the person. But an unregistered vehicle is an unregistered vehicle that can be towed at any time. There's a whole body of law around that. With regards to
Christian, I think part of the challenge is that in a lot of instances the common property for a body corporate is considered private property rather than public property. But it is something that under the proposed amendments, it does provide a definition of a motor vehicle, referring to the Motor Vehicles Act. It doesn't. So if I were joining the dots together, I would say that if it's a motor vehicle, registered or not, and it's parked in the wrong place, if the body corporate's permitted to tow that vehicle under the bylaws, registered or unregistered, it can be towed off the scheme land.
Yep.
Shall we get through the rest of the slides and then have a look if we've got any more time for the Q&A? Because I know we had a couple of pre-polled questions as well.
Yeah, we did.
And Jessica and Christian, I will just jump on one thing that we seem to miss off the slides, which I'll very briefly touch on, is the amendments to insurance schemes. So it was actually one of the big changes that came through, that it expanded the ability for bodies corporate to make applications to apply for an order that they can have an alternate insurance arrangement. And one of the changes that that came through with that, pretty much at the recommendation of SCA Queensland, was to expand that to include standard format plans of subdivision as well, because previously that was only afforded to building format and volumetric subdivisions.
Yeah, that was a good win actually, and one that we needed in the industry, wasn't it, Duncan?
Yep, absolutely.
So just a couple of things that aren't included in the bill, but from an SCA perspective, we're still looking at advocacy work for. There's been a lot of talk about code of conduct, and you'll see on the next slide there has been a bit of amendment on the code of conduct, but not it doesn't extend to a code of conduct for owners. The disclosure obligations broadened to include disclosure of laid arrangements. Now, this is a really good point that Duncan and I spoke about this morning. So, Duncan, I might pass that one over to you.
Yeah, it was just something that we discussed about the bill, including amendments to allow owners in a subsidiary scheme to perform searches in a principal body corporate, and or basically interested parties to have the ability to carry out a search of the records for a principal scheme and a layered arrangement. But one thing that did spring to mind through that discussion was that there currently does not appear to be an obligation for a vendor to disclose a principal subsidiary arrangement to a potential purchaser of a property, which seems like quite an omission, because the principal scheme can impose significant burdens and obligations onto a subsidiary body corporate.
Yeah, and look, the other 2 points, just very quickly, mindful of time here, is removing the double negative in the audit, statutory audit motions. And again, from Duncan, just the bug to inclusion of electronic voting as well was the other thing that it hasn't been dealt with, but still on the forefront of our minds when it comes to advocacy, and where we need to still promote for those practical amendments that really would impact most schemes out there as well.
And other amendments worthy of note: access to body corporate records can occur electronically. I know all our strata managers are very excited to hear the seal is gone. It's going. No need to keep a box full of them any longer. Code of conduct amended to not unfairly influence motions and committee elections. As Jess noted, that does not extend to creating a code of conduct for owners. And amendments to bylaw enforcement process in layered arrangements. Is there anything you wanted to add, either of you, that probably should be talked to a little more?
I might just quickly touch on the code of conduct one. While it's certainly a good amendment to the codes of conduct, it is worth noting, and this is something that SCA will take up, is that the code of conduct doesn't actually apply to caretakers who do not also have a letting agreement with the body corporate.
Correct.
It only applies to caretaking service contractors, which by definition are caretakers that also have a letting arrangement. So it's something that we're really pushing for to include the code of conduct to apply to caretakers who do not also hold a letting agreement. But then throwing back to the discussion that we had about the terminations of scheme was just interesting. An interesting note that I made, that similarly caretaking service providers that do not also have a letting agreement are not afforded any right to object to the termination of a scheme or the process of terminating a scheme. So it just seems to be an omission or maybe a misunderstanding of that terminology throughout these amendments.
Just on, Shauna has asked a good question as well about the application of economic reasons. And Christian, I'll be interested to hear your thoughts, but my reading of the bill is section 81 capital A sub A deals with schemes that are used for commercial purposes, and then sub B would deal with either mixed-use schemes or residential schemes in terms of the definition of economic reasons. Would that be both of your take on the bill?
Yeah, absolutely, Jess, yes.
All right, perfect. Now, mindful of time as well, we did have a couple of other questions that came through, but I think we've sufficiently covered them. Christian, what do you think?
Yeah, I think we've probably sufficiently covered off on them all. They're mostly about, yeah, the alternative insurance arrangements. As I noted, there was a lot of excitement about the seal going. I think all the managers maybe can do a bonfire of the seal. We might do an SCA event where everyone can put their old seals onto a bonfire, and never may we see them again. But yeah, look, everybody, I just want to thank everyone who attended on short notice, particularly thank Duncan, Jess, the other members of the SCA staff who helped us put this webinar together. I encourage everyone to be proactive about communicating the nuances of these changes to their committees before that rogue secretary starts yelling at people that they can't smoke on the balcony anymore instantly, or things like that. But yeah, and I also want to pay tribute to the legislation committee of SCA Queensland and the board, who have worked very diligently on trying to get us to this point where a bill is in Parliament for over 2 years now. There's a lot more to do to really bring the BCCMA to where we'd like it to be, but we hope, we're very optimistic that there'll be another reform bill coming soon. So yeah, just a big thank you to everyone who's contributed to this webinar, directly or indirectly, and particularly to you and Duncan, Jess.
Oh, pleasure. Thank you, Christian, for all your help as well. And I think for everyone that's dialed in, stay tuned. This isn't going to be the only webinar. Like what we said before, we're going to be working hard on getting out some really useful information to you on what this bill is going to mean, especially if it's passed. So please do stay tuned, and we'll have more to come.
Likewise, thank you.
Thank you, everybody.
Thank you.